So hello everyone and welcome to our June webinar with me, Emma O'Connor, and you will see that I have been joined today by my colleague Mike Hibberd. Hi Mike, thank you so much for joining us.
Hi everyone, good to be here.
So Mike is a partner in the employment team here at Doyle Clayton, and he's also a data privacy lawyer as well. And Mike heads up our litigation team here in our Reading office. So it's fantastic that Mike can join us today for our Navigating the Employment Tribunal webinar. So Mike, how are things with you and what's currently on your desk?
It's a really busy time in litigation at the moment. Generally, as we'll come on to, the statistics show claims are up at the moment. More people are bringing claims, and I've got all sorts of claims on my desk at the moment, both for claimants and for respondents. For example, whistleblowing, discrimination, claims around TUPE, unfair dismissal, breach of contract, really the whole suite of claims at the moment. And hopefully today we'll go through it in a bit of detail, because it's a bit like a game of chess. There's certain tactics that need to be considered and things we need to going forward. So it's great to be here today.
Thank you very much. Yeah, game of chess is a very, very good analogy. So for those of you who don't know Doyle Clayton, we are a specialist workplace and commercial law firm. We have offices in Reading, in London, in the city, and in Bristol as well. And we look after clients, not just in the UK, but also support clients across Europe and also globally. We have many different areas of specialism for which we can help our clients with, employment obviously being the area that we are talking about today, litigation, training, etc. But also we're doing a lot of work with our clients with regards to workforce planning, global workforce planning, so looking at business immigration, what that looks like in terms of sponsorship licenses and visas, as well as investigation. So those high-level confidential investigations, we are supporting clients with that, as well as corporate, commercial and employee ownership trusts. So get in touch if you want to find out more about what we are doing and how we are supporting our clients. And just a little bit more about Mike and myself. So Emma O'Connor, I am a partner here in the employment team, and I also head up our client training team as well. And again, the contact details there, and who doesn't love a QR code? So if you hold that up, hold your camera up, that will take you to our LinkedIn page where we can become LinkedIn friends. And you can also become LinkedIn friends with Mike as well, because here's his QR code and his contact details as well. So again, please do get in touch with Mike if you've got any queries or anything that we've discussed today on the webinar. Also, just to give you a little bit more information about our training team, what we're doing, training our clients, whether that's HR teams, boards, and management populations as well, supporting our clients there with management training. So, for example, doing a lot of training on preventing sexual harassment, obviously with the new preventative duty that came out in October. Also doing training on how to run disciplinary and grievance procedures. And I'm talking to clients a lot about, thinking about obviously the Employment Rights Bill, what that might mean. Lots of training is going to be needed, particularly around probation periods, managing performance, and of course, managing absence. So do get in touch, as well as the webinars, as well as in-person client training. Also running an HR masterclass, and I'm running this both at the moment in Reading and in London. Going to be running it again in Bristol, but that's going to be in the autumn. So if you would like to book on and join, I have a few spaces remaining on the 2nd of July in Reading. The 16th of July has sold out in London, but I have put on a second date of the 23rd of July. Masterclass is basically, a whistle-stop tour of all things employment law related, aimed at HR, drafted for HR. It's a chance for us to meet and chat and work through scenarios and case studies in a small group environment. And Kevin in the marketing team there has popped some information in the chat if you would like to find out more. But again, please do get in touch if you would like to book. Can also run this course in-house. A number of clients have come forward and I said, can we run this for their HR teams? So again, yes, I can do that. So lots of opportunities there to get involved, either at the London and Reading sessions or in person as well. Our next webinar webinar Wednesday will be on the 9th of July. Really excited about this one. I am running a session with Dawn Barnes, who's a HR consultant, but we're going to be talking about how we create those happy workplaces. And I think that's a really nice one to do just before the summer break as well, so we can put plans and strategies in place before the September recess. So again, sign up to receive our invitations. But again, looking forward to seeing lots of you on the July webinar as well. And again, I think Kevin's put the subscription link in the chat. So please do sign up to receive invites, not just to our webinars, also to find out about our newsletters and also our training courses as well. So that signing up to that subscription list is really the kind of one-stop shop for all the things that we are doing in the employment team and across Dore Clayton as well. If that wasn't enough, we have a podcast, DC Talks. So again, please subscribe to that wherever you listen to your podcast, but we are on Spotify and Buzzsprout. So get involved, listen to that podcast series that we've got. And again, if you miss any of our webinars, we do have a YouTube channel as well. So again, you can catch up with all our back catalogue, as they say. So to today and what we're talking about navigating the Employment Tribunal. So as you know, we are live. This is a general overview. We can't give specific advice, but if you want help and support, then please do reach out to either Mike or myself, either in the chat or the Q&A or after the webinar, and I'll be giving you details about how you can do that. All cases are different, all employers are different, all respondents and all claimants are certainly different as well. So again, this is an overview giving you some tips, some strategies, some things to think about. Maybe you are embroiled in a tribunal claim at the moment, maybe you think you've got one brewing, or maybe you are in the luxurious position of never being able to have that personal development opportunity of being a witness in an employment tribunal. But I think it's really important that this is an area that we do talk about. And the reason why we are talking about it today is because we have employment tribunal statistics. They are quarterly. So these are the statistics that were for October and December of last year, and they were published in the March of this year. And they show a trend and a pattern that claims are up. And Mike's alluded to that as well in terms of what's across his desk at the moment. So claims are up on last year's comparable figures. We also see there, don't we, Mike, that as well as live claims, we have a huge number of claims which are referred to as multiple claims. What do we mean by multiple claims?
Yes, it's a really good question. So multiple claims are where a claim is brought by more than one claimant against a respondent arising from the same facts. So you might sometimes refer to these as a group action. For example, in equal pay cases, you'll have seen in the news, retailers and supermarkets have these huge equal pay cases. There's thousands of claimants, but it's all the same facts, so they're all grouped into one. So when we say multiple claims, equal pay is a very common, employment status is a very common one as well, if there's a similar set of facts arising. And as you can see, 424,000 are multiple claims, some huge group actions. But of those 43,000 live single claims, it's worth noting that from the same period last year, that's a 31% rise in the numbers. So claims are definitely on the way up. And the other really interesting thing we're seeing is that tribunals are receiving more claims than they're disposing. What that means is there's a bit of a backlog and cases are taking longer to get resolved. So there are more claims coming in than the tribunal currently has resource to dispose of or reach a judgment on. There's a recruitment drive in the judiciary, so they're trying to clear the backlog. But I think that cases are taking a long time to be listed at the moment.
They are, and I think you're absolutely right. I mean, just to go through the terminology. So when we talk about a claimant, that's generally the employee. So the employee brings a claim against their employer. So we would refer to them as the claimant, and the employer, so the person receiving that claim, we refer to as the respondent. So you're absolutely right, there is a drive, and we constantly see, don't we, adverts for part-time judges in the employment tribunal system. And they have tried a system at the moment, haven't they, of having sort of litigation assistance. So again, trying to get some of that sort of, day-to-day tribunal work that's kind of being taken off the judges and being done by sort of more qualified litigation assistants. So we'll have to see what that does to bringing cases down. We should also say as well that the tribunal always, if you like, cater for more cases than they actually hear, because a lot of cases do settle, don't they? They do settle it during the process, which I know we'll talk about. But just in terms of the length of time it is taking, what are you finding there, Mike?
The latest case I've heard of at the moment got listed the other day for 2028.
Oh my
So we're not just looking
gosh.
at 2026 diaries now, 2027, I've got a few cases in. But yes, depending on the region. So we'll come on to that on the next slide, that different
Yeah.
cases are assigned to different regions, depending on the complexity of the case. So anything more than a week, 2, 3 weeks, you could be looking at 2028, which causes difficulties in itself, which we'll go on to in a bit.
Absolutely. Yeah. Yeah. I mean, and I think it is really important. As I said, many of you might be listening to this thinking we've never had an employment tribunal claim or haven't had one for many years. But the impact of a tribunal claim on a business can be, immeasurable really, particularly when we think about costs, not just, legal costs, but the costs in terms of lost time, manager time, HR time, lost productivity as well, the impact that this can have on things like, engagement and morale. I mean, trying to recruit, what is one of the first things that a potential candidate will do? Well, they'll, give you a search, won't they? And if they're seeing, employer embroiled in, XYZ claims, it might put them off actually, wanting to work for you and your organization. So there is, not just the engagement and morale of your people, of your workforce and your teams, but also that reputational impact as well. And that can be on a business, that can be on a team, and that can also be on an individual. Because particularly when we think about discrimination and harassment claims, these are claims that can not only be brought against the employer, but also against individuals as well. And often we see claims that are brought not just against the employer, but individuals, for example, individual managers that perhaps have been involved in the allegations, sometimes the HR teams that are involved in the allegations. So again, there is this personal liability element, which should not be underestimated. The other interesting point is, Mike, that it's not just ex-employees, is it, that can bring employment tribunal claims?
No, it's absolutely right. There are some types of claim where you have to have left employment. For example, unfair dismissal. Obviously, there needs to be a dismissal, or a breach of contract, if it's brought in the tribunal, has to be after the employment has ended. But claims such as whistleblowing, discrimination, work status, they can be brought by people within your workforce at the moment. And again, that needs a lot of sensitivity around how you deal with it when they are still in the business. You still see them day to day. So it's a really important point to think when you get a claim form, is this person still in the business and employed at the time or not?
Yeah, absolutely. Yeah, that is a very, very tricky one to navigate. Also, we have to think about not just costs, time, productivity, impact on the victim, impact on the claimant, but also compensation and how much that might be. We talk about remedy. That can sometimes be financial compensation, but it could also be sort of re-engagement as well, back into the business. So there are issues that we need to think about. And also there, I've put down DSA, data subject access requests. Why can they sometimes be important within the litigation process, Mike?
There's probably two strands to why they're important. Firstly, if someone is thinking of bringing a claim, you might suddenly receive a big DSAR, you might suddenly receive a load of work there, and it may well be that an individual is looking for documents that will help them shape their claim form, help them work out what their claim is going to be, and work out the allegations. So it's important in that context to consider, is there going to be possible litigation in the background? I mean, you still have your DSAR duties, you have to disclose what is disclosable under the DSAR. But the other important point to think is that a DSAR disclosure exercise is different to what is in the employment tribunal. So it's very common, and I see it with clients very often, that the documents disclosed in a DSAR, which are just personal data referring to their data subject, is different to what is in litigation disclosure, where it is documents relevant to the dispute. And we'll come on to disclosure in a lot more detail later on. But it's worth
Absolutely.
noting that just because you've done a desal for someone doesn't mean that you don't have to do disclosure down the line because they've got documents already. They're two separate processes, and that's quite a common misconception.
Absolutely. And I also just think, the DSAR, if you do get a data subject access request as well, it's really important to engage with it. So if you do find that you are getting those as an organisation, then again, get in touch, because I think that early reviewing of everything as well is a really important part, and a part of the kind of overall strategy as well, whether or not you have a claim or you think you might get a claim. And as we know, the employment rights bill is sort of hurtling towards us. And again, I think this is going to make us focus a lot more on employment tribunal claims, because there's going to be a greater risk, isn't there? We know that there's going to be an enhancement of employment rights under the Employment Rights Bill. The particular one there is obviously day one unfair dismissal rights, fire and rehire, collective redundancy as well. So there's lots of changes within that bill that have been proposed that will impact litigation and future litigation. And also the Employment Tribunal now is already sort of struggling under the strain of what we have at the moment. Again, what might that look like? We're also going to see, potential there for the limitation period, so that time an individual has to bring a claim within the Employment Tribunal. The proposal there is to increase that from 3 to 6 months. So again, what's that going to look like? We will see annual compensation increases anyway. Employment for unfair dismissal at the moment, the maximum compensation there, we're looking at nearly £120,000 or 12 months salary, again, whichever is the lower. And again, we've got this new sort of employment task force, employment police force, whatever you want to call them, but the Fair Work Agency, which is going to have greater powers in terms of investigation and supporting individuals in terms of bringing claims. So there are lots of things bubbling away that are going to have an impact on litigation, on employment tribunals, and it's really important as a business, as an HR team, that you start focusing on how that's going to impact what you're doing, your processes, and where you can get help and support. So let's think about the litigation process, and obviously the preamble to that. And that really is when we think about the ACAS Early Conciliation Scheme. Now, in most scenarios, you will know that a claim is coming because the employment relationship has ended acrimoniously. The employee has told you that they will see you in court, or you just, you get a sense that this is not just going to end here. But sometimes, Mike, it's that early conciliation, that ACAS contact, which really kind of kicks the whole thing off. So give us a little bit of background about what early conciliation is and what clients should be looking for, what employer clients should be looking for.
Absolutely. It's a really important part of the process. Firstly, it's mandatory in 99% of cases for a claimant to go to early conciliation first. I say 99% because there's a very limited caveat if someone's bringing an interim relief claim on whistleblowing, essentially where they're claiming they want to keep their job throughout the whole process. I've seen one of these on my desk in my years of doing litigation. There, they don't have to go to ACAS, but we assume they do. So you'll often get a notification. Someone, usually in the HR team, will be told, we act for ACAS, the conciliatory body, and we have a claimant here or prospective claimant who is engaging. Do you want to try and resolve the matter now? I think it's
By phone or by email, just thinking about the kind of internal comms around that.
It's nearly always by email. So normally you'll get an email from ACAS, and it's a really important part of the process because as an employer, you can start to try and understand, well, what is the individual looking for? What are they seeking? Now, there's no obligation at all on a claimant to tell you exactly what their claim is or to really even engage in the process. But if someone is looking to resolve the matter soon, it's quite useful to try and flesh out some details at this point. So I think it's a really important part of the process. There's also nothing to stop a claimant saying they're going to claim for one thing and then bringing a completely separate claim down the line. They're not bound by it. And while early conciliation is mandatory to engage with, all the employee needs from it is the certificate at the end saying that they've gone through the process. It isn't actually mandatory for them to engage in conciliation and try and negotiate a settlement at all. Quite often they do, but there's nothing to stop a claimant calling ACAS saying, I'm bringing this claim, I want my certificate today, and they just issue it. So most of the time, you understand a claim's coming because ACAS have contacted you, but it's not unusual for an employer to not actually find out about ACAS at all until the claim form hits the desk at a later point. So I think it's just worth making that note that just because you don't hear something from ACAS within 3 months of an employee leaving, that doesn't necessarily mean there is no claim, albeit you would normally expect to be contacted.
Yeah, and early conciliation was basically set up to try and, if you like, filter out the claims that could be settled so they wouldn't then hit the tribunal process. But you know, as you said, Mike, there's really all the individual needs is just that reference number, and then they can then go and, you know, file their claim with the Employment Tribunal. And so how long is the early conciliation period for?
It's up to 6 weeks.
Up to
And
6 weeks.
most of the time, if they engage with the employer, it'll be for the full 6 weeks. Now, there's an advantage to the claimant in doing that as well, because the time limit to bring a claim is stopped while they're in early conciliation. So if they use the full 6 weeks in conciliation, they've got 6 more weeks to put their claim form together and put the details together, start drafting their documents and whatever else they want to do at that stage. So when we say here, what's the effect of settling or not? Obviously, if you can settle an early conciliation, there is no claim. That is the purpose of early conciliation. It removes it from your desk nice and early. Some employers like to engage early, some don't. It's entirely a business decision. But I think it's always quite useful to know that early conciliation is there. And another preconception that I see, often from opponents who might not have a legal representative, is once early conciliation ends, it can still be settled via ACAS at any point. It's not a be all and end all if the claimant gets their certificate. You can still engage with ACAS at any stage in the process.
That's true. That is true. So early conciliation, and then we kind of move through, don't we, to sort of the start of what we would call the litigation process.
Yeah.
Obviously, the employment tribunal system is more complicated now. There are rules that govern the rules of procedure. There's the duty to the court, overriding objectives, etc. that we follow. So we get the claim form, and that's obviously filed online by the claimant. And again, where that ends up, so what tribunal that ends up at, really depends on where the individual worked. So it may be that actually we have regional tribunals spread across the regions, helpfully, but often it might be, so for example, if a claimant worked in for example, your Bristol office, but your HR team is based in London, it would go to the Bristol office, but again, you just need to think about how that works. So we get the claim form in, and again, then we have that period, don't we, of 28 days to file our defence. When we're thinking then about the defence that we're putting forward, are there any kind of sort of top tips there that you would have, for respondents?
Absolutely. I think the first thing to do is really try and grab the bull by the horns, as it were, when looking at what the claim form is. In theory, the whole parameters of the case will be within that one ET1 document. Now, the form itself is quite short, so they might not put a huge amount of detail in there. But usually you'll know the background and you'll be able to flesh out what the gist of the claim is. And I think it's really important to try and work that out early on, because you've got to try and assist the tribunals and the courts. You don't have to make a claim for a claimant. You don't have to guess what the claim is. But if you do think you can work out what it is, then you should say so. What I would usually do with my clients is come up very early on with a schedule of allegations, because that will set the roadmap and how you go about it. 28 days is not a long time. I should also say that you normally get the claim form by post. So if you include the delays in postage, you will have likely far less than 28 days to put that defence together. And I think it has to be actioned really quickly. You need to know who in your business is going to deal with the claim form going forwards. Now, usually that will be HR, but upon a poster receiving it, it needs to go to HR so they can work out the appropriate next steps. Depending on the type of claim, the claims might be really complex as well, and there might be managers you need to speak to in the business to get their account. There might be a whole number of documents that you need to collate and gather as well. So I think working out what the allegations are, creating that schedule, and working out who you need to speak to about what is really helpful. And certainly as a legal advisor, it really helps me when clients have started to think about that. I'll put together the schedule for them, and then we can work out what documents that we need to make that 28-day deadline.
Yeah, exactly. I think that the key word there is engagement, isn't it? Engaging across the business. This isn't just, this is not an HR thing. This is something that, the business needs to sort of work through. And you're right, front loading the process is actually incredibly helpful because it kind of helps you plan your litigation strategy moving forward. And I think the other thing that also helps with sort of planning and, getting that sort of timetable involved are obviously things around directions. Often we agree a list of issues with obviously the court and the other side. Sometimes there might be a kind of this idea of a preliminary hearing. What is that, and in what types of cases might we see a preliminary hearing?
Yes, these are very often listed. Just to go very quickly back on the defence to two very quick
Mm.
points. If you don't file your
Oh,
defence
yes, of
within
course.
time, you will get what's called a default judgment, which means that the claimant will win, regardless of the merits of the case. If you fail to file one, you have to apply for an extension of time, and that's a very strict hurdle. The other thing I often see is in complicated claims, or if it's sat in the wrong part of the business for too long and they haven't forwarded it to HR, you might not know the full answer to all the allegations by the end of that 28-day window. And again, you should engage with your legal advisors on what to do there. Sometimes you might need to reserve the right to amend the defence at a later point. But I think the most important thing to say is in the defence, don't guess. If you don't fully know an answer, don't put it in your defence, because the worst thing you can do is put your position into that formal court document and then need to change it down the line. So it's really important to be front loaded at that stage. But going back to your question, Emma, on preliminary hearings, yes, so most complex claims, and by complex, I mean things that might need a panel. So whistleblowing, discrimination, or if there's preliminary issues such as strikeout for no reasonable prospects or a claim being out of time, will likely get a preliminary hearing. There are two types. One is for case management, where essentially the judge will sit down with the parties, set the case for a final hearing, and set out what steps need to be taken to prepare the case for a final hearing. And at that, you'll work on what's called a list of issues. This is one of the most important documents that gets overlooked in the tribunal process. It will essentially outline all the allegations under each claim and what the court will be looking at the final hearing. And that list of issues is such a good roadmap for the parties going forwards when you're looking at disclosure, which we'll come on to, when you're coming onto bundles, when you're coming to witness statements. A really well prepared list of issues really does help set your position and make it clear what you will need to be looking at.
And I think what I want to do is sort of focus on just sort of two key areas. And really that's around document disclosure and I think being a witness, because I think they are kind of the key areas that I think HR are typically involved in, but also the wider business as well in terms of engagement. Now, document disclosure, obviously we're lawyers, we love paper. It's, kind of gets us excited to have a nice bundle of documents in front of us. But there are some really important considerations when we think about the documentary evidence that's going to support your claim. And often what we do is we sort of, again, I think you're right, list of issues. What are the documents that are going to support, obviously, what you're trying to say, what your case is, but also the list of issues that have been agreed. Just want to kind of go back to that bit we talked about at the beginning around kind of, the different types of disclosure. It's not necessarily everything that we would disclose. Obviously, take advice in terms of when documents are without prejudice or where you're trying to settle you're genuinely trying to settle a genuine dispute between yourselves. And also when you've got lawyer correspondence, again, when that lawyer is giving you actual advice, CCing a lawyer into every comms is not going to make something legally privileged. So again, take advice on that. But this idea of the DSAR versus litigation might just kind of give us a bit more information about why that is so different and how sometimes clients can get it confused in terms of, well, we've given the individual everything. why are we now having to give him or her more in terms of the court?
Absolutely. So disclosure is a very strict duty. I should sort of preface that by saying all of the rules I'm talking about today are set in what's called the Employment Tribunal rules. There's a set of rules which outline the procedure and what you need to do. Now, when it comes to disclosure, it's not like some scenarios you see in other countries where you only disclose documents that help you or prove your case. In England and Wales, you have to disclose anything that is relevant, subject to the caveats there. Now, when you look at what is relevant, again, I would go back to that list of issues which you've worked very hard on at the preliminary hearing to agree with the other side. Is documents that help your case, is documents that neither help nor hinder a party's case but are relevant, but it's also documents that hinder your case. So if they when you're compiling your documents, hopefully early on for your defense, if you know there's a document that's going to potentially be an issue down the line, or it might not look good in the cold light of day when tempers have calmed down and there's something in writing that was said, which in hindsight probably shouldn't have, it's really important to be aware that you have to disclose it. You can't hide a document because it's unhelpful. You can't hide a document because it doesn't look good or it's embarrassing. The duty of disclosure is really strict. And that's the duty of disclosure there, and it relates to anything relevant to the case. Compare that to a DSAR, where it's only their personal data. So you might have third-party data that you can redact because it's not their personal data. There might be documents relating to business plans and management, which are not relevant to a DSAR, but are relevant when you come to disclosure. So they're two very different processes. And regardless of whether they've got the document already, such as an employment contract, it's still a document within your possession. And if it's in your possession and it's relevant and it doesn't fall under an exemption, it needs to be disclosed.
So what if something has been deleted?
If it's still in your possession or you're still able to retrieve it, then I'd say it's still disclosable. Obviously, if you what we often find is there's a bit of back and forth with the other side on disclosure. Either you think there's a document that should be there that's missing, or they say this document doesn't exist or we can't find it. A really common preconception is about once you've done disclosure, job done, we'll move on to witness statements and we'll do the bundle. Disclosure is an ongoing duty. So it is quite common that when you are later down the line, a new document comes to light that wasn't retrieved in the initial searches for whatever reason. As soon as it is retrieved and it's in your possession, it is disclosable. So again, it's important to really get your ducks in a row when it comes to disclosure. It doesn't look great if you're doing lots of piecemeal disclosure throughout the proceedings, but if you have a really solid, thorough disclosure exercise at the start, it helps set you up and it helps show that you know what you're doing when it comes to the litigation.
Yeah. And there is nothing worse, sorry to say, there is nothing worse as well than being actually physically in the tribunal, in the hearing, and it coming to light that a document or an email is not in the bundle because it just looks terrible, and it kind of goes to that whole credibility. It's not a good look.
Absolutely. I was just going to answer very quickly the final bullet point. What if something's missing? Now, normally you start engaging with the other side to say, there aren't any documents here. For example, if it's a claim relating to your mitigation, relating to your job applications, we know you've got another job. There's nothing here on the income you've now got, those types of things. But it happens with respondents as well, where claimants say there's documents missing here. Now,
Yes.
if they still do not come out, there are applications you can make to the tribunal for specific disclosure. But I find most of them are you try and deal with it before having to use the tribunal's time and resources. You try and find the documents that are being requested that are relevant.
So document disclosure is kind of one of those key areas. And again, often we encourage clients to do that at an earlier stage because it's better for us to know if there are any, kind of skeletons lurking at an earlier stage when we're writing when we're assisting with the defence or we're looking at kind of overall strategy. It's much better to have that information, to know it early than to have it, as we were just about to enter the tribunal door. So again, one area to really focus on is the documents, is the evidence. What do you have? What do you need? And where are you going to get it from? And who might you need to get it from as well? And that's where really kind of being a witness as well kind of comes, doesn't it? In terms of, you know, focusing on being a witness, what that looks like. We have witnesses obviously to kind of bring the case, to give their own, you know, first-hand information. And one thing, just a couple of things on being a witness is obviously who, you know, might be a witness, Mike, and also this point about where that witness might be, because I know that's come up quite a lot in cases that we've been working on.
Absolutely. And to explain witnesses, they are the ones that will explain the documents, will bring the bundle to life. So once you've gone through disclosure, you have a joint bundle with the other side. It's got your relevant documents and their relevant documents. When you come to a tribunal, witnesses will give what is called evidence. And the way they will do that is they will have a written statement which is prepared in advance and exchanged with the other side at the same time. And that is their evidence. They don't read it out. The judge will read it and will say, right, that is your evidence. And the other side will then ask about it. When it comes to who your witnesses are, it's a really important point to grapple early on in terms of your litigation strategy. If you're taking the C-suite out of your business for 5 days, 10 days, it's relevant. If you have a witness who is left the business, do they leave on good terms? Was there a dispute in that one? It's relevant to know because you might not have a witness available, which you'd hoped for. That's particularly a problem if we're getting cases in 2028 now. That's 3 years down the line. So it's something we need to be alive to. In terms of where the witnesses are, if they're located overseas, you need specific permission for them to be able to give evidence from overseas. Sometimes that's a fairly easy process, depending on the country. Sometimes they might need to fly into the UK to come and give their evidence. Again, it's another complication you need to think of as you're going along. And then when we say when they're a witness, it depends on the type of case. If you have an unfair dismissal only case, the respondent will give their evidence first. What that means is once the judge has read the papers, read the witness statements, the respondent witnesses will go first. In contrast, in a discrimination case, it is the claimant who gives their evidence first. Now, this is always subject to a caveat where it's up to the judge at the end of the day how they want to do it. I've seen quite often where a claimant is unrepresented, they might ask the respondent to go first, just so the claimant can understand how evidence is given and what will happen as part of the process. Again, it's not a set rule, it's really at the discretion of the judge. And I think the other important thing about being a witness is your witness statement is key. What you put into writing there is you asserting the truth to the tribunal. And it's not like in America where people walk around the room shouting at witnesses or pointing fingers. It's a bit more relaxed than that. But it's really important to know your witness statement is your evidence, and you want to make sure everything you write in there is truthful and is credible. And on this slide, Emma, just to carry on, so what to focus on, I think one of the most important things, and we can help you with this, it's got to be your own account. You can't be guessing in your witness statement something that you think happened or you overheard from someone else and you've got hearsay on that. If you weren't present at the time, think about how you can really give evidence on that point. For example, if there was a sexual harassment allegation and you heard from someone else that it didn't happen, but you weren't present at the specific place at the specific time, you're not really going to be able to add much to that evidence. I think it's really important for it to be authentic. One of my pet peeves are witness statements where it is so obviously drafted by a lawyer. For example, there was one that we were dealing with which had a schedule of defined terms on page 1. It looks like a law contract, essentially. And whilst that looks very impressive, the judge will see, well, is this even your evidence, or have your lawyers crafted it for you? It's got to be in your voice. It's got to be in a professional manner, of course, but it's got to be the way that you speak. It's got to be your own account. And as I say, it's got to be facts within your own knowledge. If you don't know something, then you can't give evidence on it because that will undermine your credibility at a hearing.
So important, yeah. So we've got our list of issues. We have done our document disclosure. we have prepared our witness statements and we've exchanged those, and we do exchange them simultaneously, obviously, so we can't have a situation where people amend their witness evidence after seeing the other sides. So we then get to the hearing. Now, when we think about the hearing, like, things have slightly changed, haven't they? And we have sort of a bit of a kind of a mix of in person or remote. And what are you finding? Is that becoming more remote hearings, or is it up to the parties? What kind of happens with that?
The parties can express their preference whether they want it to be a remote hearing or an in-person hearing. Different factors apply. Some people want the formality of going to a physical court and resolving the dispute that way. Sometimes people are happy for it to be remote, and it's called cloud video platform. This is a real shift we saw from COVID when we had lockdowns and the courts were not open. They started having a lot more hearings held online, and that's a trend that has continued. I'd say about 75 to 80% of my cases these days are dealt with remotely on cloud video platform. We still sometimes do have in-person ones, but I'd say more remote now than were before. The other thing I should mention, when it says who attends, is a public hearing.
Yeah.
So members of the public can attend any final hearing or a preliminary hearing to decide specific issues such as employment status or strikeout or things like that. I think I already mentioned who goes first. So depending on the type of case, unfair dismissal, usually respondent, discrimination, usually claimant, but the judge does have some discretion. And what happens at the hearing is your witness statement is what's called cross-examined. And that will mean the other side, whether they've got a lawyer or not, and they might have assistance from the judge if they don't have a lawyer, will ask you questions on your statement, asking you to recount events and seeing if there's any holes in the evidence that they can pick out or anything that they disagree with. So it's a really important process, and you could do a whole session on the hearing and witness statements, but at a high level, you're being asked in your statement, and is this true or is this not? The next
Exactly,
question.
and that's the role, isn't it? The role of the claimant's advocate is to pick holes. They're putting their client's case to you and saying, this is what happened, isn't it? They're looking for faults. I think the key thing with cross-examination is just not to argue, stick to what you know, as you said, Mike. No guessing. Be respectful, but you stick to the facts. In terms of what you can talk to, and don't speculate. And one thing just about the hearing, we should say that this isn't a sort of a county court or a criminal court. So judges or panel members, if it's going to be a panel decision, they don't wear wigs, they don't wear gowns. Sometimes claimants, sometimes respondents as well, are not represented. They may be, presenting the case themselves, and again, solicitors or barristers. Again, we don't wear wigs and we don't wear gowns. But how should people kind of, approach, what to wear at hearings, or perhaps not to wear at hearings?
Yeah, it's a really good question. I always say it's a court of law, so you should be formal. I mean, by way of example, during the COVID pandemic, I had a hearing online, and sadly, the claimant forgot about the hearing and turned up in his dressing gown. And we all muddled through as we could, but it sets the wrong impression and the wrong tone.
Another kind of gown not to wear.
Exactly. So even if it's an online hearing, treat it still as a court. I'd still say dress smart.
Yes.
Now, for some businesses, that might be a business almost like a branded uniform, like a branded top. That might be an example. In some industries, that might be a suit, it might be a jacket. You should feel comfortable, but it should still feel smart and respectful. So I'd always say err on the side of caution, but what is appropriate to your business will depend. The next question I've got here is, will we get judgment on the day?
Yes.
Again, the judge will always try to, if they can, give a judgment on the day, because it's good for the parties to know and then to be able to move on and the dispute is resolved. Depending on how complex it is, depending if there's any delays in the evidence being given, depending if there's any unforeseen hiccups during the trial, I find it's more common for judgment to be what is called reserved. So a judge will say, I've got too many papers here to give you a judgment in the next hour or so. we will go away, we will review the evidence, and we will give our judgment in writing. So I'm finding reserved judgments are a lot more common now. Even if you get a judgment on the day orally, you can still ask for the reasons to be in writing if you think that will be beneficial. One thing I would say there is a judgment is public. So it will then go onto the public database. And again, if you've got job applicants who are doing job searches, they'll be able to find the case depending on the strengths of Google and depending what else is there on your business. So it's worth remembering that if you get written reasons, or even if you don't, but it just says this claim worked and this claim didn't, if you get written reasons, they will be a public document.
Yeah. And actually just sort of, thinking about, judgments and what that might mean. Obviously, we've got sort of issues there around, things to really remember, Mike, from your perspective around kind of litigation.
Yes, and I think there's a few concluding bullet points here. The first is we're seeing an uprising claims, and it's always worth thinking when you're writing an email, when you're having that meeting, actions can lead to litigation. And so it's always having that in the background. Whenever I write a letter or an email, I think, how would this look in front of a judge? Because you never know at what point a dispute could arise. Commercial considerations are really important. That's why you front load it at the start. You get your roadmap, you work out the allegations as best you can. Who are your witnesses going to be? Is that going to be an issue? What is the likely value of the claim as well? Is it a low value, I owe some expenses, or I'm owed a bit of notice pay, or is it a high value whistleblowing discrimination case? That's all relevant commercial considerations too as well. I say litigation is unpredictable. Always expect the unexpected, because at the end of the day, it's an adversarial process. Everyone's got their own approaches to litigation, but be aware that things can arise down the road that you're not expecting. Again, that's why legal advice can help, because we've seen more of these unexpected turns before, or we can advise you the best way to go. And what are the lessons learned? I think that's a really important point, that regardless of whether you win or lose in litigation, I do this with my clients all the time, there's always processes, there's always things that could be done better with hindsight. So I think it's important to try and understand, if you've gone through the stress of a 18-month, 2-year hearing, well, 2-year case, it's taken 2 years to get to a hearing, reflect and think, so what could have gone better when the employee was with us? What could have gone better that might not have led to this dispute? I think there's always learnings to be taken from any case. And the final bullet point there is, if a party is unhappy with a judgment, they can appeal to the Employment Appeal Tribunal. Now, the scope of appeals is relatively small. It has to be an error of law, or what's called a perverse error of fact. And the hurdle for that is very high. But it's worth noting that even when you've got a judgment, there's this 42-day window where a party can appeal. So it might not always be the end of it.
Mike, we've had a question in actually, and I think we'll deal with that now, around about being a witness. And if you're called to be a witness, can you be forced to be a witness?
That's a really good question, and it normally happens when someone has left the employment. So sometimes you might be what's called summons to be a witness, where essentially you are told you will be attending on this date, and if you don't, it will. I believe it's a contempt of court if you don't attend.
Yeah, it is.
And I'd have to triple check that, but I'm 95% sure. Unfortunately, if you get a witness summons, yes, you do have to attend. I very rarely use witness summons, to be honest, because I'm hoping there's another witness in the business who can give me that account, and that might be a reluctant witness.
Well, that's the thing, is it? I've had situations where we have summoned a witness because they wanted to be summoned, because they could then say to their new employer, look, I have to go. So sometimes it's been asked for. The difficulty is, if somebody is summoned, they're a hostile witness, aren't they? They're kind of a little bit of a loose cannon. We're not entirely sure what they're going to say. Will they be supportive of our case or not? So yes, you can be. But again, I think from a tactical perspective, it would be one that we would use rarely and with caution. So
and I think, sorry, just to follow up. So that question, I think, speak to your new employer. The question that's coming in, I think speak to your new employer about what the fact you have had a witness summons in. I think it's important to engage with them because you have to be a witness, in short.
Exactly, yeah. So if you want to find out more about what we do, what we can help you with, again, this is just some examples, particularly around the kind of the data subject access request. So the kind of the pre-litigation stuff, as well as obviously helping support you. We also run mock employment tribunals as well, which are always good fun, particularly when we get someone from the board to sit and be the judge. So they're always good fun as well. But again, get in touch, even if it's to kind of chat about the merits of the case as well. It's really important, I think, sometimes to have that kind of, extra pair of eyes and extra scrutiny on a case. So again, do please get in touch. And just before we go, again, this is, we don't want our clients to sort of end up in situations. So again, it's those lessons learned, those practical steps that you can take. Again, thinking about your policies, are they updated? Are they clear? Thinking about training for managers and HR teams as well, and thinking about that early intervention. But as Mike said, it's really important that if you do find yourself with an employment tribunal claim, that it's not about blame, it's about engaging with the process and finding the right way to be able to kind of, forge your path, whether that's settlement, whether that is going to the tribunal. So Mike, thank you so much for joining me today. It's been an absolutely fascinating discussion, I think, particularly around that, being a witness, don't speculate, don't guess, and don't argue. Is probably the sort of the top tips that we can leave with.
Perfect. Thanks everyone for joining.
Thank you. So keep up to date, get in touch if we can help. And again, don't forget our next webinar next month. And again, if you're interested in the masterclass, again, we can get you booked on. So again, looking forward to seeing all of you next month. And in the meantime, have a wonderful rest of the day.